The first home game in a few weeks.
We're getting everybody in.
Let's see.
Okay. All right. So it looks like the RPA is. Why does Calabasas keep getting pushed out? Hold on. All right. Okay. So it looks like RPA was a good thing for the end of the year. I thought we should end the end of the year with a refresher on the RPA. So that's where we're at. So let's just get right into it because can't hear. Is that everybody can't hear or just Lynette? Can everybody hear me?
Yes.
Okay. Lynette,
Yes,
I think it's
yes,
you.
we can hear you.
Okay,
Yes.
great. Thank you. Lynette, I think it's you. Sorry to say.
Are we recording?
Yes, it is recording.
Oh, thank you.
So let me get into it because this usually takes me a while to do. Share the screen. Okay. All right. So what you should be seeing is the RPA is bundled with a whole bunch of other forms automatically. The very first form is always going to be your agency disclosure regarding agency relationship. So I usually don't go through the other forms, but I wanted to go through them really quickly because they're referred to in the RPA and it's easier to really see them and then relate them into the RPA. So the disclosure regarding real estate agency is just that, a disclosure that there are several different types of agency relationships, a seller's agent, a buyer's agent, and an agent representing both buyer and seller. And that this is required by law. And the first page is basically explaining the different types of agency relationships and what the buyer and the seller's responsibilities are. And then your client signs them. And the second page is what the actual code, the law is, or the ordinance is, and it's actually a law. It's a duplication of how it appears in the books, so that's all the civil code, how it appears. So, and then you're going to see here confirmation you will see that's the second part of the law. The first part of the law is to disclose that there is an agency relationship and the types of agency relationship. And then the second part of the law is to confirm which agency relationship you have with the client. And always remember that the agency relationship is with the brokerage, not with the agent themselves. Even though the agent signs, it's with the brokerage. So that's the first form. The second is the Fair Housing and Discrimination Advisory. We do not discriminate. We don't steer people to specific neighborhoods because of their ethnic makeup or religious makeup of a possible religious makeup of a neighborhood. We don't do that. We don't work with clients who do that because that becomes a liability for you and the brokerage. So if you have a client who, like a seller, who says, well, I don't want to sell to a specific protected class, then you need to explain that that is a fair housing violation, and they can be sued because of that. And if they persist, then you should get rid of that client. So that's what the second form is, and you can read this and go through exactly what it is. Because the emphasis today is on the RPA. Possible representation of more than one buyer or seller. This is telling the buyer or the seller that, hey, my brokerage represents other buyers who may be vying for this property. Also other sellers who have similar properties. That's all this piece of paper is disclosing. There may be somebody else in my office writing an offer on this. There may be somebody else in my office representing the seller, and that's a dual agency. So that's all this form is doing, and that's the possible representation of more than one buyer or seller. Wire fraud, very important. Wire fraud, Mr. Buyer or seller, that I, as the agent, will never send you wiring instructions. You need to make sure that that is clear, that if you get wiring instructions via email, you should confirm those wiring instructions with escrow directly on the phone, not through an email. And because there is wire fraud out there, and the default to send funds is through a wire transfer because it's the most efficient way to do so, but it also poses its own risks. So make sure that they are aware of the wire fraud. So now we get into directly the RPA and what we're here for today. And this is the offer. Make sure that you date it, the date it is prepared, because there are other forms that come consequently that are going to be based upon the RPA that was dated in this date. So the date it's prepared is just as important as anything else, and it's an offer from a buyer, and that buyer can be an entity. We'll get into entity at the end when we go to signing, but an entity can be a trust, could be a power of attorney, it could be an LLC. And the buyer would be that entity. So just make sure that that's clear. The property acquired is, and that's basically the address, and then you add the parcel number. So and if you don't know where the parcel number is, you do a quick search. You should be doing a quick search of property profile in Realist, and that will tell you who the seller is, because you need to know who the seller is. And so and it will also give you the parcel number, and plus it's also in the MLS. So so that's the important part of who the offer is from and what property we're bidding on. I'm already getting dry. Okay, agency. Well, we just did that agency disclosure at the beginning, and it has to be the very first thing that your buyer signs when you're doing an offer. But here's that second part that's required by law, and that's the confirmation. So the seller's mortgage firm, you put the firm's name and the firm DRE number. And are they representing the seller, or are they representing both the buyer and the seller? Now, remember, agency is with the brokerage. So having been with the brokerage, so if there is a listing agent in the very same office that has the listing, then it is dual agency. Now remember, all of my offices have separate DRE numbers, so they are separate corporations. So a listing agent from Calabasas and a buyer's agent from West Side, that is not dual agency. Those are separate agencies and separate brokerages. So it's important to know that. So is the seller the brokerage, is it being represented, they only represent the seller, or are they dual agent? Also important note, what if it's a for sale by owner and you're not representing the seller? So that happens. So you're not representing the seller, so you leave it blank. And there's another form saying a seller non-agency disclosure, saying, Mr. Seller, I'm not representing you in this transaction, but I will be giving you paperwork. I will be, there are paperwork that is required by law that I will be giving you, but I'm not representing you in this transaction. And then vice versa for the buyer. If you're representing the seller and you're not, the buyer is not represented by any agent or agency, then there also is a buyer's non-agency disclosure. So that's important, and you would leave that blank. But if they are being represented by a brokerage that has a DRE number, that information has to go in there. And if it gets screwed up on the RPA, then you have to redo it on another form called an agency confirmation, which is just this very to be on a separate form, and both parties have to sign it. So it has to be right because it's required by law. So then we go to D. C, if more than one brokerage represents the seller or the buyer, then there is an ABA, which is an additional brokerage acknowledgement. So that would be added there. So, but most likely it's just going to be one brokerage. All right. So potential competing buyers and sellers. Well, what form do we have to notify the buyers and sellers of this? It's one that we just looked at, and that's the possible representation of more than one buyer or seller. So there you go. So so now getting into the crux of the offer, and that the first thing is the purchase price. How much are they offering? And you will see that the terms of the agreement is item 3, then it goes ABC, and so on. But then there is another section here, and it says paragraph number, and it gives different numbers and whatnot. Well, that refers to the paragraph later in the contract that explains more about this item. So it always refers to further in the contract. So if you want to know a little bit more about the expiration of an offer, then you can go to paragraph 32A, and it's going to tell you about that. So just keep that in mind. So first off, what's the purchase price? Is it all cash? If it's all cash, then you would check it's all cash. Close of escrow. It's usually a number of days, 30 days, 45 days, but it could be a date. Now, here's where, if you're representing a buyer, that you really need to be in touch with the lender. It may not be a lender that you're normally working with. The buyer has his own lender, but you have to create this relationship with this person, because you need to talk to this person and say, hey, can you do a 30-day escrow? There were times when we were really busy and everything was, going crazy, and lenders couldn't do a 30-day escrow. They're going to say, no, make it 45. So you have to ask that question. The second thing is, does it need to be date specific? I worked with a client who was a freelance production person, and we had to close at a time when she was employed, so that during that last week or two when they're going to verify employment, we needed somebody to verify it with. So it was dates, but she knew she was going to be working on a specific show for these 8 weeks, and so we set it for that timeline. So that's important. So that's a reason why for it to be date specific. We're coming up to the end of the year. A lot of people want to close before the end of the year because of tax purposes. So that's something else too. So okay. So that's close of escrow. Expiration of offer. It defaults to 3 calendar days at 5 o'clock. Now you can change that. You can make it 2 calendar days. You can make it 5 calendar days. Whatever. You can make it whatever. But that is when that offer expires. Initial deposit amount. We like to see 3%. So now other areas, Northern California, for $1,000, they will take $1,000, initial deposit. But because of liquidated damages, we like to see 3%, and that's the norm in Southern California. So and then it goes within 3 business days after acceptance by wire transfer. That is the default. Now, if you're a listing agent and the buyer's agent says, "Oh, we're going to give you a check," or they include a check, don't touch the check. As the broker, we don't want you to touch a check, because the minute you touch a check, it has to be logged into the trust log. It has to be copied. That check has to be tracked. So we do not want a check. So just to let you know. Increased deposit. Sometimes they will do an increased deposit. It's known that, okay, we'll give you 5,000 now, and then we will increase the deposit to 3% after inspections. This is all negotiable. So if the seller's willing to, and it's the seller, remember, you're representing the seller. You don't make decisions for the seller. Everything in the contract has gone over with the seller, and it's the seller's decision whether they want to accept it or not. So if they want to accept those terms, then there's nothing wrong with that. The third, if there is a loan, so if they're putting 20% down or 10% down and there's a loan, you would put the loan amount there, and most likely it's going to be a fixed rate, or in these days it might not be, but who knows? So it's very important, once again, to work with the lender as far as what the rates are, and because you want to fill this out, that the rate is not to exceed a certain amount. If you leave it blank, it's like if rates go crazy, while you're in escrow, say when you go into escrow, you're at 7%, and then while you're in escrow, it goes to 8%. That's a percentage point that creates more money that the buyer has to pay monthly. But if that buyer can still qualify for that rate, they have no out. So that is why you want to put an amount, a cushion, a little cushion. Say it's 7%, okay, not to exceed 7.5. But you once again have a discussion with your seller as to what's good for them, because and then the buyers to pay up to X amount of points. A point is usually 1% of the loan amount. So if it's a $500,000 loan, it's what is 1%? I can't do the math off the top of my head because I have too many things going in my head. And then default is 17 days after acceptance is the removal of the loan. Also, make sure that you're filling out, it defaults to conventional. If it's other type of loan, if it's an FHA or VA, any other type of loan, make sure that you specify the type of loan. Because if it's a VA or FHA or VA, then it automatically triggers another another form, basically saying that it has to appraise for the amount that you're buying it for. You cannot waive appraisal on an FHA or VA loan. So just know that. So that's the first loan. Then E2 is if there is a second loan, and it would be the same. It would be the same the same parameters. You will want to get a rate and all of that. So E3 is occupancy. Is this their primary? It defaults to primary if it's a second home or if it's an investment. That matters because if they're saying it's their primary, they're getting rates for a primary, and then they don't. It's really a secondary just to get a good rate. Number one, that's bank fraud. You don't want to be involved in that. Number two, banks are checking that information, and if the person gets caught, then it's severe penalties. So this automatically calculates as to what the loan amount. If it's an 80% loan, then it will calculate after the initial deposit and whatnot as to what the balance of what the down payment is and the total purchase price. Before I moved on to the next page, anybody have questions on the first page? Not seeing or hearing any. Second page, first one, seller's credit. Or if the buyer is asking the seller for any credit. I just got an email from somebody who said they want the seller to credit for a buy down of the loan. So that would go here. That's a perfect example of what that is for. Or they just want a credit. Years ago, first time buyers, we're getting credit, asking for credits. Depending on the market, sellers may have gotten them. Additional finance terms is, I'm trying to think of what an additional finance term. The buy down could go here also if you didn't want to put it in the seller credit, or I can't think of anything right off the top of my head. G3 is the brand new thing that confused everybody when it came out. So this is only applies if there is a buyer broker agreement in place. So if there is a buyer broker agreement in place and you want the seller, you're asking the seller. Now here's the example. If the seller is offering 2% and your buyer is agreed to pay you 2.5%, and you want the seller to make up the extra 0.5%, you use this form to ask for compensation. Here's where another way that this could be used. If you have a buyer broker agreement in place that the buyer agrees to pay 2.5%, the seller is offering 0, which, remember, that is a possibility now. But if you have a buyer broker agreement in place, you now can ask the seller to pay your 2.5%. Since the buyer is offering 0, you're asking the seller to pay it. Now, so that's another reason why to have a buyer broker agreement in place.
Rich,
So yeah.
Quick question, if that
Mhm.
happens, where do you put the percentage in? Because I just see a place where you check it.
Right, it's in the form.
Okay,
You have to look at the form.
okay,
The form will say the seller is offering, and you add 0%, and you're asking the seller to pay 2.5%. So that's where you would do it.
Rick,
But only if you have a buyer broker agreement. Okay.
quick question.
Uh,
You said
sure.
now it's in effect, but the lawsuit has not been decided or completed yet. So
Doesn't matter. The NAR has agreed that sellers can offer 0%.
that's
We're
we-
not waiting for the lawsuit to come in. People aren't waiting. That's why if you're on a listing agreement, you have to explain to your sellers that it's customary for our office to offer 2.5% to the cooperating broker. And this is why it's important for you as the seller to offer this compensation, because there are buyers out there who that amount cannot be financed, and there are buyers out there who don't have the cash to pay their agents. So we're are looking to the seller to pay that compensation. So that's why it's important to have that conversation with sellers as well as with buyers. So
can you also add in the additional finance terms section, personal property such as furniture, it does not have any value for the loan
No.
officer?
no, that's because it's not finance terms, it's other terms. So that would be where other terms, and then you would do an addendum, listing whatever you're asking for. So
I have a question.
sure.
You just said that the brokerage fee cannot be financed, but it has been historically. If you buy a house for 500,000 or your loan is 500, the seller in the past had always paid the 5%, and it came out of the
Their proceeds.
buyer's mortgage.
No, it
Correct?
came out of their proceeds. Came out of the seller's proceeds.
But it was being financed by the buyer.
No, it's not being financed.
Oh, no, I'm sorry, you're right.
No, it's not being financed. Okay. Verification of cash defaults to attached. And same with verification of down payment and closing costs, and verification of loan application. The default is attached with the offer. I don't know of any listing agent who will accept an offer where they're not seeing up front that this person has the cash and is approved, and also how they're approved. Is it a pre-qualification? Is it pre-approval? Or is it an fully underwritten pre-approval? So that's that. Final verification of condition, 5 days. The default's the 5 days prior to COE. I stress that it is in your buyer's best interest to make sure that you don't do it on the date of closing. Because if something's wrong, it's too late to do anything about it. So do it on that 5th day prior to close of escrow, if at all possible. So that's that. Assignment request. It's defaulting to 17 days after acceptance. This agreement can be assigned without approval from the seller. After that, the seller doesn't have to approve it, can approve it, but they can't object to it within that 17 days. Okay, so loan contingencies, as I've said, that it defaults to 17 days, or there is no loan contingency. Appraisal contingency, it defaults to 17 days, or there is no appraisal contingency. And then I want to point out, appraisal under appraisal contingency L2, appraisal contingency based upon appraised value at minimum of purchase price. Or if you check that box, then you can put in an amount less than the purchase price. Say you're offering 100 and it's 100, you know, in my lifetime, $550,000 for a property. So you can say the appraisal contingency is based on the appraisal value at the minimum of purchase price, which would be 550, or if you check that box, 525. What does that do? That says that the buyer is willing to move forward if it appraises for less than value at 525. That means they're willing to come up with $25,000. Now, if the purchase price, these are in the counters now, if the purchase price changes, you have to remember that differential stays the same. So if the purchase price then becomes, if you agree on a purchase price of 575 and it appraised for 550, without removing this caveat, the buyer has to proceed. Is that clear? Anybody have questions about that? We
So-
used to have to write, go ahead.
Yeah, this is Emilio. Hey, so you would put on there not to exceed like 25,000 or something like that over,
No, you would put the purchase price minus that amount.
okay, so
So,
50, you would put any 25 under
Right.
525.
right,
Got it.
right, exactly. Yeah.
So Rich, what if it's more and my buyer's still willing to pay the difference? What if it's the appraised value is 500 and $50,000 is the difference?
If
Then
your buyers are willing to proceed, then they're willing to proceed. But this is the buyer's out. If it doesn't appraise, if it appraised for less than the amount that they've agreed to, then they have an out. If they still want to proceed, they can proceed. You know, that's up to them.
Great. And I just wanted to ask you a quick question on the page before, or no, not the page before, on this page, number H1 and H2. I have a very qualified buyer that always asks me that I don't have my current loan pre-approval or my statement. I prefer, he has it, but actually he prefers to give it after offer review. So 3 days. He always
And is our listing agents accepting this?
well, the one offer I did, he didn't. The other ones didn't even ask. So I guess it's just by luck. But he always insists that he's not going to give me any paperwork or backup before. And I tell him it's just I don't know what else I can tell him. Can you give me some like sentences or some sort of a script that I can convince him to give it to me?
If you were selling a property, wouldn't you want to know when you were looking at the offer? If you have several offers in front of you, the worthiness of the person who is making this offer, because basically you're saying, I'm not willing to tell you whether I can proceed with this offer until you look at it. And yeah, if you were selling a property, would you accept that? Because most people wouldn't.
You know,
That's the only thing.
Account balance is too large, and
You can't argue with stupid. I mean, I just have to be blunt. You just
I
can't.
know, but is
So if they don't want to do it, they don't want to do it. You can't force it, and that's what you have to do. So if they don't, and hopefully, Susie, I have to move on because this is a long contract, but hopefully you'll find somebody who will take it. If he gets turned down enough, then maybe he'll get the idea. I mean, stupid is stupid as far as I'm concerned. Okay. Investigation of property defaults to 17 days. Of course, you can change that. Informational access to property. This used to be hidden somewhere. Now it's right out in the open. So a lot of people, This is if you change the investigation of property to 10 days, but leave investigational access to property at 17 days, then the buyer has the right to come in, bring in architects, do all of this stuff. It's not a contingency. It's measure for drapes, measure for shutters, do all this kind of stuff. And they have the right to come in to access to the house. So that's what that informational access to property. Review of seller's documents. It defaults this. The buyer has 17 days to look at the documents that the seller provides, or 5 days after delivery, whichever is later. So if after those 17 days you're given a different set of documents to look at, then you have 5 days. The buyer has 5 days to look at it and approve it or cancel because of it. Preliminary title, same thing, defaults to 17 days. Once again, all these numbers can be changed. Common interest disclosures, 17 days. Review of leased or liened items like a solar or water softener. If this is contingent on the sale of the buyer's property, then it defaults that it's not contingent. If it is, then you check the box and another form comes up, the COP. Time of possession. It's now defaulting to upon notice of recordation. Used to be 6 o'clock on date of recording, but now it's when it records, they have possession. If the seller wants to stay in possession, you would check one of these boxes. The first, if it's 29 days or less. I want to stress that if the seller is staying in this property for 1 day, 1 day after close of escrow, you need this form because it protects all the parties. If it's 30 days or more, then it's the residential lease after sale, RLAS. Occupied units, if it is tenant occupied, even if the tenant is moving out, you need to check that box and fill out the TOPA. Next is seller delivery of documents. The seller has 7 days to deliver their documents, their disclosures. 7 days. A lot of sellers, a lot of listing agents don't hold sellers to that, but they have 7 days, and they have 5 days, and a lot of the parties don't do this. 5 days to sign and return escrow holders' provisions and instructions. The escrow officer has the duty to make sure that these people who say who they are these people, and they need that paperwork back because it has the person's information, where they lived previously. This is all ways to verify the identification of the individuals. So it's important that for whichever side you're working on to make sure that they return these documents to escrow. Time to pay fees for ordering the HOA documents. The seller has 3 days to pay the fees. 3 days. So that's really important because we all know that HOAs take their time. And here's another important thing: install smoke alarm, CO detectors, and water bracing. Seller has 7 days to do that. For those agents, and I was one of them, you waited to the end to do retrofitting because you know that retrofitting is required in the city of Los Angeles. You waited until all contingencies were removed. Well, that's too late because that stuff needs to be done within 7 days. Evidence of representative authority, 3 days. That means the escrow is usually going to take care of this. If it's a trust or if it's a probate, that paperwork will be asked for by escrow, I can't remember what it's called, the trust and the actual trust. So they'll take care of that. So the second page, any questions on page 2 of 16? Not hearing any. Okay. Next. What items are included? Check all the boxes that are included. This is important. Wine refrigerator. I had somebody who had a wine refrigerator that was, it was just sitting there. It wasn't attached, but it was sitting there, and they had checked refrigerators, and the listing agent says, well, now they want the wine refrigerator. I said, it said refrigerator, so technically they're entitled to the wine refrigerator. That listing agent had to go out and buy them a wine refrigerator to replace it. So check everything that's included. If there's anything that the buyers want excluded, have them check that and list it there. Allocation of costs. Historically, the seller pays for the NHD report, and do an environmental. It's not that much more. It's like $20 more, and it gives the buyer a little more information. And remember, do a CRES NHD report. It helps all of these offices. Click here for an additional report. This wildfire service provider report, it's in the revised RPA. It's going to be a section by itself. I haven't really seen one of them that you really need to do this just yet. I don't really see a need to do it just yet. I don't see a value in it, to tell you the truth, because part of the law taking effect in January 1st is that it's going to be clear, really clear on the NHD that whether the property is in a high or very high fire zone, and that counts as state, county, and local. They're going to separately indicate that. So as long as you know that information going in, I don't, the wildfire service, report, I don't really see a need for it, but
Rich,
maybe
is that
some
going to
people.
is that going to be taken out January 1st or no? Or we don't know yet?
It's not going to be taken out. It's going to be added as a drop down, I believe. It's going to be added as its own section. So you can it'll be kind of like I'm not sure. I haven't really seen it, but I know that that's the only change in the RPA is about this wildfire report. And I think it's just a drop down, option that you can do. So, other reports, don't fill that out. Don't, because I see that buyer, a general inspection report, the buyer's going to pay for a general inspection report. Don't do that, because the minute you do that, the lender, if there's a loan, wants to see it, and you don't want a lender to see it. Same with a termite report. You don't want a lender to see that. Don't put termite report. The seller is going to pay for a termite report. Termite should not be in the RPA. It should never, because then the lender is going to want it to be a clear termite report. So you cannot negotiate for, we'll do the work later. You can't do that, because the lender is going to insist that it's cleared. Smoke alarm and CO2 detector bracing. It's customary that seller pays for that. Government required point of sale inspections or reports. That's the 9A. That's the retrofit. And customary that seller pays for that. Customary that seller pays for corrective or remedial actions. Point of sale. Escrow fees, each pay their own fees. Don't put 50-50 because it's never 50-50. Owner's title, customary that seller pays for that, buyer pays their own title insurance. County tax, customary seller. City tax, customary seller. HOA fee for preparing disclosures, customary the seller, defaults to the seller, and the certification fee to the buyer. Then HOA transfer fees, unless otherwise agreed, seller shall pay for separate move in, move out. So sometimes the seller gets charged to move out of a HOA area and the buyer pays to move in. So that's that. Private transfer fees, just check that seller if applicable. Because it should show up on title if there are private transfer fees. So home warranty, customary for seller to pay, and remember to get these CREST home warranty policies, and there's several different companies that are writing them. So other terms, if you wanted, Susie, if you wanted the other terms as far as private property, personal property, I don't want this to time out, to be transferred, then you would put that there and then add an addendum. Other terms also, a good thing for other terms also is that if the buyer or somebody is a real estate agent or has a real estate license, you should put that there, or that, buyer is related to buyer's agents, or, stuff like that. That stuff goes there too. Any questions on page 3? Not seeing or hearing any. Okay, so the addenda, if once again, if it
Rich,
was
I
a
have a
tenant,
question.
yeah, sure.
Sorry to interrupt. You said don't put
Sure.
termite in there. That's understood for obvious reason. Now, if the buyer says, I want to do a termite, I guess he can do it during his inspection, and then you can
Yes.
come back with the credit saying, listen, you're
Yes.
going to pay 10,000 for fumigation or not.
Yes,
Right?
absolutely. That's where it needs to go. Because remember, on the request for repairs, there's a separate section for termite, and it addresses the termite there. So, but the lender doesn't see that.
You're right.
And a buyer should always do that. Should be part of their inspections. It costs $100 unless it's gone up since the last time I had ordered one, but it doesn't cost that much to do a turnaround inspection. So the buyer should be doing it, shouldn't rely on one that the seller did, because they're using their company. So
No,
yeah,
you're right. But I'm saying negotiation for who's going to pay for it should come afterward, not during the first process.
right. No, right. Right. Because remember when we used to do it all those many, many years ago, we would negotiate in the contract that the seller is going to pay for section 1 in the contract.
Right, exactly.
So the seller was agreeing to repairs that they didn't know. And what if it came up $15,000? Well, the seller already agreed. It's like, so that's why it was taken out of the RPA. It shouldn't be in the RPA, and it's where it should be, which is in the request for repairs.
Right, I get it. Thanks.
Okay. The addenda, if it's obviously, if it's a tenant occupied, the TOPA, probate, any of these things, you would add those addenda. You should also add the Keller Williams ABA, affiliated business addendum, because if you ask for services, you should know that all parties should be made aware that we have an affiliation with, if we're asking for, we have an affiliation with my NHD. If you're asking for my NHD, they should know that we have an affiliation with my NHD. So all of that. So now we get into those paragraphs that we were talking about that are basically explanations of the terms. So the first having to do with the deposit, the initial deposit, the increased deposit, and then very importantly, the A3 retention of the deposit, meaning we get to keep the deposit. So if initialed by all parties incorporated in this agreement specifies a remedy for buyer's default, remember, buyer's default. That means if the buyer has removed all contingencies and they don't close escrow, they are in default. So buyer and seller are advised to consult a qualified California real estate attorney before adding any other clause specifying a remedy for failure of buyer to complete the purchase. Any such clause shall be deemed invalid unless the clause independently satisfies the statutory liquidated damages required set forth in civil code. So that's just putting buyers on notice, or buyers and sellers on notice, that don't start, drafting language to get around retention of deposit. All cash offer. If it's an all cash offer, no loan is needed. This agreement is not contingent on the buyer obtaining a loan. Buyer shall, within time specified, deliver written verification of funds. That goes without saying. Okay, so then we go into loans, the different types of loans, the balance due, deposited with escrow holder, limits on credits to buyer. This is very important. Lenders have limits as to what they will allow the buyer, the amount of credit that the buyer will have. So once again, have that relationship with the lender. If it's a $500,000 sale and the buyer is asking for $100,000 to credit, and thinks they're going to get $100,000 credit, and by some miracle that the seller said, okay, I'll give you $100,000 credit, and then go to the lender, and the lender says, no, you can't. You can only get a $30,000 credit, and that's all we will allow. Well, that other $70,000 is not going to come from the seller. They're going to sue you, the agent. So you have to know what that limit is. It's usually, a rule of thumb is 3%. That's usually what it is, but it could be different. So that's why you need to check with that lender. Verification of down payment, verification of loan applications. Any questions on this page? Not seeing any. Okay. Buyer stated financing. I get more questions about this than anything else. Buyer says they're going to do a cash loan, they're going to do all cash. Then suddenly they want to go for a loan. Well, they can do that. Sellers relying on buyer's representation of the type of financing, including but not limited to all cash, amount of down payment, or contingent or non-contingent loan. Seller has agreed to specific, closing date, purchase price, and to sell the buyer in reliance on buyer's specified financing. Buyer shall pursue the financing specified in the agreement, even if buyer also elects to pursue an alternative form of financing. Basically, yes, Mr. Buyer, you can try to find a loan. But it goes on to say that seller has no obligation to cooperate with buyer's efforts to obtain any financing other than what's specified in the agreement, but shall not interfere with closing at the purchase price at the close of escrow date, even if based upon alternate financing. Basically saying, buyer, if you can close for the price on the closing date, going with a loan as opposed to with all cash, good. Everybody wins. Seller gets, but if buyer now needs extra time because they're thinking of going alone, seller says, you said cash, you showed me cash, you got to close on this date, and that's it. So that's what that means. Closing in possessions. If seller intends to occupy for primary, secondary residence, or unless otherwise agrees, that goes into TOPA. That talks about occupancy, that it's important really to disclose what kind of occupancy. Condition of property on closing. So unless otherwise agreed, 7B1, remember this paragraph, 7B1, unless otherwise agreed, the property shall be delivered as is. This is in the contract, as is, in its present physical condition as of the date of acceptance. The property, including pool, spa, landscaping, grounds, is to be maintained in a substantially the same condition as on date of acceptance, meaning they can't suddenly stop the gardener, stop the pool service. It has to be maintained. So, and all debris and all personal property, not including the sale, shall be removed by close of escrow at the time of possession is delivered to buyer. If not on the same day, if items are not removed when possession is delivered to buyer, all items shall be deemed abandoned buyer after the first delivering to seller written notice to remove the items within 3 days. May pay to have such items removed or disposed of, and may bring legal action as per the agreement to receive reasonable costs from seller. As I've said before, this is a gift because abandoned property as part of the law is 30 days. In this contract, 3 days. 3 days. So in this contract, if they don't remove it when the buyer takes possession, buyer has to give notice, you need to remove this in 3 days. Otherwise, it's mine. I can get rid of it and I can charge you. I can take you to court, small claims court, and charge you to get rid of it. So that is a gift to the buyer. Okay. Buyer is strongly advised to conduct an investigation of the entire property in order to determine its present condition. So that's really, really important. Seller remaining in possession, we talked about this. It's really important to get those forms because it protects all parties. At close of escrow, seller assigns to buyer any assignable warranties. Seller should otherwise agree. Seller remains in possession. I get this argument all the time. Sellers remaining in possession, they don't want to turn over the keys at close of escrow. They'll do it when they vacate. Well, this is, what number is this? 7E, seller shall at close of escrow, unless otherwise agreed, and even if seller remains in possession, provide keys, password codes, and other means to operate all locks, mailboxes, security systems, alarms, intranet, blah, 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 blah. So at close of escrow, they need to turn this stuff over. Even though they're staying in possession, that buyer, it's their house, they can come and inspect with 24 hours notice, all of this. So that's very important. Contingency.
Question.
Sure.
If the seller leaves property that the buyer wants to keep, then they still need to give the 3-day notice?
Yes. Because if after 3 days they don't remove it, then it's theirs to do with what they want. It's abandoned. So if they want it, if they want to keep it, then they keep it. And the seller has no claim to it. So yeah. All right. Contingencies, loan contingencies, talks about appraisal contingencies, and we went over all of that. Investigation of property and review of seller's documents. So any questions on that? This page? Okay. Title. Talks about the title report. If your clients have questions about the title report, refer them to your title rep. Don't answer questions about title. Let the title, that's what they're there for. And then the buyer has 5 days after receipt to review a revised preliminary report. And then it talks about buyer review of leased or liened items, removal or waiver of contingencies. Buyer shall have no obligation to remove a contractual contingency unless seller has provided all required documents, reports, disclosures, and information pertaining to that contingency. So if the buyer, if the seller hasn't provided their disclosures, TDS especially, because it's required by law, and the listing agent is saying you have to remove your contingency for seller's documents, it's like, well, you need to give us the documents before we can remove it. It's in the contract, and it's, you know, so that's important. If buyer removes or waives any contingencies without an adequate understanding of the property's condition or buyer's ability to buy, buyer is acting against advice of agent. What does that mean? If you didn't do all your due diligence, or you removed a loan contingency before you were given approval, that's on you, and you're acting against the advice of. It used to say the broker, now it's saying the agent, which is one and the same as far as this contract is concerned. For any contingency specified in 3L8 or otherwise, buyer shall, within the applicable period, remove the contingency or cancel this agreement. But remember, this is an active contract. And these are active contingencies, meaning they cannot be removed unless they're removed in writing. So just because the days passed, just because your days have passed for that contingency removal, that doesn't mean that it's gone away. Not until a seller has given a notice to perform, and then you still haven't removed it, then the seller can cancel. But it just doesn't automatically go away. It has to be removed in writing. That's why about a year or so ago, there were those contracts written by other brokerages. They wrote their own contract, and in that, they removed the active part of a contingency. They made them passive contingencies, meaning that you know, if you had 10 days to remove a contingency, at the end of those 10 days, it was gone without any written notice. So it's important, if you're getting brokerages own contracts, make sure you advise them to seek the advice of their own attorney. You can't advise them on that. Going into items included and excluded, and leased items. Any questions on this page? Not seeing any. We're going back in allocations of costs. Let's go to government required, legally required installations and property improvements. This is smoke alarms, securing the water heater, carbon monoxide. Those are required by state. We also, in LA, city of LA, it's a point of sale requirement. So those have to be done. And I've said it before, I will not waive a retrofit or requirement in the city of Los Angeles unless it literally is a tear down. there is so much liability. It's like, especially if somebody is living there prior to close of escrow, and buyers change their minds. Oh, we're gonna remodel it and nobody's gonna live there, blah 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 blah. And then I'm gonna rent it out. There was no carbon monoxide, and then the heater goes out and people die from asphyxiation. And I bought it. It just becomes a whole thing. So unless it's a tear down, I won't do it. Reinspection fees. This is important. If any repair is not completed within the time specified and the lender requires an additional inspection, seller shall be responsible for any corresponding reinspection if buyer incurs costs to comply with lender's requirements. A lender requirement is to have carbon monoxide detectors. So if they're not there at the time of the appraisal, that will be noted, and a lot of appraisers charge to come back to make sure that it's there. So the seller would be responsible for that reinspection. So that's why it should be done within 7 days of acceptance. So cancellation, statutory and other disclosures. These are statutory. TDS, NHD statement page is statutory. If it's in a high fire zone, that's statutory. Lead-based paint, if it's before 78, that's statutory. So these are all required by law. So a seller cannot say, I'm not going to fill that out. It's required by law. And if they still refuse, then you go to the buyer saying the seller is refusing to do this, and then the buyer can back out because they don't have it. Any questions on this page? Let's see. Okay. We go into fire hardening, lead, defensible space, waiver prohibited. Just as I said, you can't waive these. And buyer shall, within the time specified or 5 days after delivery of any of the disclosures, sign and return them. Termination rights. If any disclosure specified above is delivered to buyer after the offer is signed, buyer shall have the right to terminate within 3 days, 5 days, 3 days after delivery in person, or 5 days after delivery, if they don't agree with any of these, anything on these disclosures. Withholding tax. You only really would be dealing with withholding tax if the seller is a foreign, what does it say here? I can't find it. If it's a foreign national, that escrow may require that withholding tax be kept, and the buyer is responsible for it. So if that should come up, then you should have a discussion, have escrow have a discussion with the buyer as to what their excuse me, what their responsibility is. Megan's Law, this is where sex offenders, they can look up by the address, see where they live. It's a scary thing that, you'd be surprised. Notice regarding gas, the pipelines that that exploded about 10 years ago up in Carpinteria, I believe it was. So there is a website to find out where the pipelines are. And then natural and environmental hazards. That's what your NHD report is for. Any questions on this page? Okay. This talks about what were we talking about condominium and planned developments. Remember, a condominium or a planned development doesn't have to be condos. It could be single family homes that have an HOA around it. Solar systems, known material facts. Seller shall within time specified disclose known material facts and defects affecting the property, including but not limited to known insurance claims within the past 5 years, or provide buyer with permission to contact insurer to get information. So even if a seller is exempt, even if it is a probate or a surviving trustee, if that seller has known knows of material facts, they need to disclose it. That doesn't release them from disclosing that. 12 goes into buyers inspections, that do your inspections, and that the seller shall make the property available for all buyers' inspections. The seller is not obligated to move any existing personal property. But this is also important. Seller shall have the water, gas, electricity, and all operable pilot lights for buyer's investigations. So if you're a listing agent and your seller doesn't have the utilities on, they have to have those utilities on in order to do those inspections. And then the buyer indemnifies the seller and the seller's property from any damage done by any of their inspectors. Title investing, don't advise your clients as to how to take vesting, that they should contact their tax preparer. Any questions on this page? All right. Buyer shall have to close out, receive a recorded deed. That's okay. Time periods. This goes into what are the time periods for these contingencies, and it's important to keep to those time periods. And the buyer may, within the time specified, request that the seller make repairs or take other action regarding the property. Seller has no obligation to agree or to respond to the buyer's requests. So that's important. You give a seller a request for repair, and well, they never got back to me. I'm waiting for them to get back to me. It's like, well, that's their answer. They don't have to get back to you. Because remember, 7B1, I can't remember what the item was, but that it's sold as is. So very important, seller's right to cancel. If you're representing a seller and you get all these offers, you need to explain to your seller, once you accept an offer, the only time you can cancel this, you are tied to this person. You cannot cancel this contract unless that buyer doesn't perform. If they're supposed to do their inspections within a time period and don't do it and remove that contingency, then you can give a notice to perform and you can cancel. That doesn't entitle you to their deposit. Make sure that they know that they don't get their deposit unless the buyer defaults. And the buyer defaults when they've removed all their contingencies. But that is the only way that the seller can cancel this agreement. I've had so many agents say, the seller just doesn't like this person. He just wants to cancel. You can't. Because what that buyer can do is the buyer can go and sue that seller for specific performance and force them to cancel if they want to go through that court action. So so that's important to make sure that your seller knows that. Buyer's right to cancel, if there is a contingency in place and the buyer something they don't like, they can't get the loan and they still have the loan contingency, it doesn't appraise, though they have the right to cancel from those. And this before I move on to the notice to perform, any questions on this
Quick
page?
question, Rich.
Sure.
So you said that the only time that the seller can cancel is when the buyer doesn't perform.
Correct.
That's just after delivering a performance warning, correct?
Notice to perform. Yes.
We can't just cancel without
No.
giving them the notice.
We're going into notice to perform on the next page.
Okay.
Yeah. Okay. So notice to perform, notice to buyer or seller to perform. So you must first give the buyer, if they're not performing, a notice to perform. And they have 2 days to perform. Now, it doesn't matter what time you give them the notice. A lot of agents will say, well, I gave it at 5 o'clock on this day. So on 5 o'clock on this second day, that's day 1. No, you give it on Monday. They have Tuesday to perform, Wednesday to perform. And then at 12 o'clock midnight, Thursday morning, seller can cancel. So you have to give them 2 full days to perform. That's the way it is. But it cannot, let me read this. If a notice to perform or notice of seller to perform is incorrectly delivered, and times, if it's incorrectly delivered, meaning if you gave it to them prior to when the contingency was up, you can give it 2 days prior to when the contingency is up. If you give it 4 days prior to the contingency up, it's invalid, and you'd have to give another notice to perform. It goes into days later on, so I'll go into how to count days and whatnot. So if the buyer has removed all their contingencies and they're not closing, you don't give a notice to perform to close, you give a demand to close. And that is 3 days. That is 3, you have to give them 3 days in order to close. So effective cancellation on deposit. This is what everybody asks. If the buyer or seller gives written notice of cancellation pursuant to rights duty exercise under the terms of the agreement, the parties agree to sign and deliver mutual instructions to cancel the sale and escrow and release deposits, if any, to the party entitled to the funds, less fees and costs paid by escrow holder on behalf of that party. If required by this agreement, any escrow fee charged to that party, fees and costs may be payable to the service providers, blah, blah, blah. A party may be subject to a civil penalty up to $1,000 for refusing to sign the cancellation instructions if no good faith dispute exists as to which party is entitled to deposited funds. Neither agents nor escrow holder are qualified to provide any opinion on whether either party has acted in good faith or which party is entitled to deposited funds. Buyer and seller are advised to seek the advice of a qualified real estate attorney. So the cancellation is in 2 parts. The first is seller cancels the contract that pursuant to the buyer not performing after giving the required notice to perform. So, and then the second is instructions about the deposit. So once that cancellation is sent, The contract is canceled. What's then in question is what to do about the deposit. Now, if both parties sign and agree on what to do about the deposit, then it's all great. But if somebody is disputing the right to give somebody else the deposit back and they don't sign, then it has to go to mediation. And you just have to let it go to mediation and have them determine it. Or you can try to negotiate, okay, would you accept returning X amount? You know, it becomes a, you know, trying to avoid going to mediation. But if a party just refuses to sign, yes, there is this civil code. Have I ever seen it successfully exercised? No. So, but it's the threat of it sometimes gets people to sign. So then we go on to repairs. Repairs shall be completed prior to final verification of condition unless otherwise agreed. Repairs to be performed at the seller's expense may be performed by seller or through others, provided the work complies with applicable law, including governmental permit, inspection, blah, blah. Repairs shall be performed in a good, skillful manner with materials of quality and appearance comparable to existing material. So, the seller can agree to do repairs in lieu of giving a credit, yes. They should be done prior to the final verification to make sure that they were done. And then we go into final verification. The buyer shall have the right to make the final verification of property within the time specified, but it defaults to 5. This is not a contingency of the sale, but solely to confirm, number 1, that the property is maintained pursuant to paragraph 7B, repairs have been completed as agreed, and seller has complied with seller's other obligations under the agreement. You cannot stop the close of escrow because you don't like what you say the repair wasn't done, you don't like the way it was done, all of this. It cannot stop the close of escrow. It can't. And then the buyer will have to close and then take them to small claims court. That's the remedy. Prorations. This is very important to explain to your buyer if you're representing the buyer, because they don't understand it. They are being taxed. Their property tax is being based upon the taxes of the seller when they bought it. Now, if they bought it for $200,000 and you're buying it for $1 million and you think that $2,000 is all the property tax you're going to pay, like I said, you can't argue with stupid. So you need to explain to them, you're going to get a supplemental tax bill once the assessor's office catches up. So expect a bill. Don't ignore it. Because I've had clients ignore it and then come after me saying, you never told me. And it's like, well, yes, I did. So that's important. This goes into our compensation and all of that. Any questions on this page? Not hearing it. Okay. Basically, 19 is basically saying that escrow is going to take this agreement and then put it into escrow instructions. That's all that says. Selection of service providers. Agents don't guarantee the performance of any vendors. We have a form that's a vendor advisory. I suggest you use that, giving them a heads up that they need to, we don't guarantee their work. We're just doing this as a service, recommending certain vendors. Multiple listing services talks about the MLS, about this is important for buyers. Basically, buyers come to agents and say, I want all the pictures taken down. Well, the MLS won't do that. Some will do that. The MLS will do that because the MLS goes by their own little world. But CRMLS won't do that. Part of the MLS rules is that there's an accurate depiction of what that listing was, and that includes the pictures. So they won't, after the close of sale, they won't remove them. Prior to close of sale, if you're representing a buyer and you know that they feel this way, go to the listing agent and say, my buyer wants the pictures removed. They can remove everything except for one exterior picture. So if you know that this is an issue for your buyer, go to the listing agent prior to close of escrow, because after close of escrow, 9 times out of 10 they can't do anything. And as far as like a Trulia or a third party, we have no control over that. So they're going to have to contact them if they want stuff like that removed. So that's important to note to them too. Assignments. They can assign this contract to somebody else within 17 days without the seller's objection. But after that 17 days, the seller has to approve it. And if the seller doesn't want to approve it, then they can legitimately deny that request. Any questions on this page before we move on?
Rich, I
Yeah.
have a lot of clients who do assignments, meaning like to a husband or to another partner. So when I write the contract, do I need to write or assignee and assignee?
No.
No need.
No.
Just the person's name.
You have 17 days between the acceptance and 17 days after acceptance, that contract can be assigned using the AOAA form.
Okay, thank you.
Okay. Equal housing opportunity. We don't discriminate. So we are in compliance with the equal housing. So I do want to go to counting days. Okay. Because this is the first day after the event is the full calendar date following the event, ending at 11:59. So for example, if a notice of form is delivered at 3 p.m. on the 7th calendar day of the month, and it's personally and is personally I lost my place. Okay, let's just go to all calendar days are counted in determining the date upon which performance must be completed, ending at 11:59 p.m. on the last day of performance. After acceptance, if the scheduled performance day or any act required by this agreement, including close of escrow, lands on a Saturday, Sunday, or legal holiday, the performing party shall be allowed to perform on the next day that is not a Saturday, Sunday, or legal holiday, and ending at 11:59. For purposes of the close of escrow, any day that the recorder's office in the county where the property is located is closed, or if the recorder's office is closed, you can't close. But okay, so it's given, the notice to perform is given on a Thursday. Friday is day 1. Saturday is day 2. Technically, Sunday at midnight, it could be canceled, but that's a Sunday. So you have to go to the next business day. And so Monday can be canceled. That's on the notice to perform. So 2 days. Same thing with demand to close, except it's 3 days. So the date of performance can't end on a weekend or a holiday. That's the basic of that. Delivered, if it's emailed, it's considered delivered. and that's important to know. Terms and conditions of the offer. Time is of the essence. Every contract says that time is of the essence. Any questions about this? Because we're almost to the end.
Rich, on demand to close, can you,
Yes.
if you know that they're looking like they're not going to close, can you give that demand 3 days before the actual closing so
Yes.
they have to close on time? Okay.
Right, you can, yeah. Yeah, just like a contingency, you can give it 2 days prior to the contingency is up. Now, if you give it 3 days, it's not legitimate and you have to reissue. But
Why would you do that, Rich, to the other side, unless it's just been really hectic with them, or why would you do it?
I mean, I've had agents on the listing side say, look, I am a stickler and to timelines. And if your contingency is up on this day, I'm going to give you a notice to perform 2 days prior. And here's the thing. If you're representing a seller, then you're really not doing your seller a service, because if you wait to give it, then you're giving the buyer more time because you lose those days. I mean, a seller doesn't have to cancel. This just gives them the right to cancel. So if they have 10 days to do their inspections, they've done their inspections, they, and they're just dragging their feet and, oh, I want one more inspection, I want one more this, I want one more that. Then that's the reason to give them 2 days prior, because
So it's
if you
just
wait
basically the seller's agent is twisting your arm to like, we're going to be a stickler for this. We want to make it happen right now.
but also, okay, the contingency is up. Say the contingency is up on Wednesday. Okay, Wednesday comes, they didn't remove it. Well, then Thursday comes. Okay, guys, when are you going to move? Oh, we're going to do it. We just have one more thing to do. Blah 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 blah. Okay, all right, okay. You tell your seller, it's like they say they have one more thing to do, and then they're going to remove it tomorrow. Okay, then the seller does the seller. Then the buyer doesn't remove it tomorrow. So now we're up to Friday. Okay, so then you issue the notice to perform. So you issue it on Friday. So then you've missed 5 days for your seller. How are you servicing your seller?
Right, I got it.
So.
But Rich, the seller was aware. I've told the seller about this, and he says, you know what, I don't want to push this buyer too much in this market. That could happen, right? I mean,
it could, sure,
it
could, but then there's the other seller who said, well, they were supposed to do it on Wednesday. Now you're saying that I can't cancel until Tuesday. You can't win.
Okay.
So
isn't it better to do this?
But here's the thing. Like I said, you issue the notice to perform. You don't have to cancel. It just gives them the right to cancel. So it's like I'm just servicing my seller. I'm protecting my seller, and I'm not saying that they're going to cancel, but that's the added pressure sometimes that buyers need. So I mean, I get it. I've been on both sides, but I can understand trying to protect your seller. So
Rich, I'm saying noticing to buyer without sellers knowing about it. We are still doing them a favor.
Well, no.
Right?
Because the seller has to
Okay.
sign it. So how?
Okay.
I mean, how is the seller not knowing about it? The seller has to
That's
sign
right.
it. No. You explain to the seller, look, they're supposed to remove it. You don't have to cancel, but if this ensures that if we're getting a wobbly feeling, a day or two after that they're still going to go even longer, then you're good to go to cancel.
Absolutely.
So,
Thank you. I got
yeah,
it.
okay. So, okay. Liquidated damages. So liquidated damages are basically the parties are agreeing that if there is a default, the limit on the amount of damages will be 3% of the purchase price if the property is a dwelling that is a residential, no more than 4 units, one of which the buyer occupies. So if it's owner occupied, liquidated damages is 3%. Now, if it's not owner occupied, any amount deposited can be considered liquidated damages. So say there's 5%. I don't know why anybody would put 5% down, but if there's 5%, then if it's not owner occupied, then that would be liquidated damages. So we can advise buyers or sellers on whether this is for them. They should consult their individual attorneys, but we can say that most people do agree to liquidated damages because most people do agree to liquidated damages because it's more expedient, but get your own advice. Now everything goes to mediation. That's not negotiable. That's the first step, is mediation. Then it's arbitration. So this is another choice that the buyers and sellers have to make as to whether to agree to arbitration. We can't advise. They should get their own advice. Most people do initial arbitration because it does save time. It is costly, as is a court. A court will take years. Arbitration can take 6 to 8 months, but it is costly. So, any questions on those? Not seeing any. Okay. So expiration of offer. Once again, the expiration of offer is usually 3 days. 3 days by 5 o'clock. Entity buyers. So this is where there is a legal authorized signing. So one or more of the buyers is a trust or corporation, LLC, probate, partnership, any of those. The agreement is being signed by a legally authorized signer in a representative capacity and not in an individual capacity. The name of the legal authorized signer is, so if it's a trust, it would be John Doe trustee or co-trustee. You can see the examples there are below it. And then if a trust identified buyers, trustee, blah, blah, blah. If the entity is a trust or under a probate, the following is the full name of the trust or the probate case. So that's where you would put 1234 LLC, Pisani Trust, or as estate of John Doe. That's where you would put the entity name. So once again, number 3, first you check the box. Number 3, the name of the legally authorized signer. And number 5, the name of the trust, LLC, or probate. So that's how it would be signed. So so then here you would go print name of legal authorized signer. When you check that box, why is it not checking? Oh, I think you got to do that. There you go. And then it fills in, and then you print the name of the legally authorized buyer, and that would be John Doe trustee or whatever it is. So if there's more than 2 signers, use the ASA. This right here, more than 2 signers. Now, remember this entity buyer thing, that eliminates the need for the representative capacity. It's all done here. It's a lot easier. So, but if don't try to cram 3 or 4 names in this. If there's more than 2 buyers, you have to do the ASA. So acceptance. So this is where the seller would either counter, put them in backup, or just accept it, sign it and accept it. And then once again, the entity signer is here, seller's signature. Is there any questions on that? Not seeing any. Okay, last page. This is where we put in our information, and we should fill this out. And you have the seller's brokerage information. Fill it out. You know, I would put in the seller's electronic information, so that you're accepting for them that they will accept things electronically, and you're accepting that once you're accepting it electronically. This part here is filled out by the escrow holder. So there is that is the contract. Any questions on any of that? I know I kind of sped through it, but it's a long thing to go through.
Where was it where you could shorten the acceptance time? Because I would never leave it to 3 days.
It is right at the top of page 15.
Oh, okay.
Buyer's offer expiration of, well, no, you do it originally in all the way in the front.
Yeah, okay, because it
Yeah.
used to be at the end. Okay, I just want to make sure it
Right,
wasn't.
no, it's up front, expiration of
okay.
offer right there. Yeah.
Okay, they changed it.
Okay.
Okay, thanks.
Yeah. Anything else?
Rich, on the first page where we have to put in the amount for the loan and the point, I never fill that out because I give them a proof of loan pre-approval.
No. How is that a part of the contract? How is a letter a part of the contract? It's not. You need to fill that out, or else you're not protecting your buyer.
So
You have to
E1,
protect your
you have
buyer.
to fill it out, E1 on the second,
Yes.
not to exceed
Yes.
whatever percent.
Yes.
Okay,
Yep.
thanks.
Okay. Anything else? All right. Thank you very much. And thank you for sticking with me. I will probably see a lot of you at the holiday parties coming up next week. If I don't see you, have a good holiday season. Happy New Year, because this will be the last class of the year. All right. So
Thank you, Rich. Thank you so much.
Thank you, Rich.
Thank you. I
Thank
can't
you.
find where
Happy
to
holidays.
stop this. All right. Happy holidays to you. See ya.